We understand the difficulty that the NC examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaguides.com. Join me in welcoming your guide for this session. Thank you.
'91 and 92 of Constitution Act 1867 divides all legislative powers in Canada, all legislative powers to enact laws, divides it between the Parliament, which is the legislature at the federal level, and the provincial legislative assemblies, which is the legislature at the provincial level. Right? Now, it's important to note, the reason I zoomed in and emphasized on legislative powers is that whilst Canada practices constitutionalism, just right beneath constitutionalism on the hierarchy of, or in the structure of the systems that operate in Canada, the systems of government that operate in Canada, just right on top of rather beneath constitutionalism is a parliamentary system of government, right? So Canada is pretty much originally, essentially, runs a parliamentary system of government. And that is why when we talk about division of powers, we're not necessarily talking about executive powers or judicial powers, where, unlike a few other countries where there's an assumption that all three levels or all three branches of government are equal or have the same status. In Canada, the parliament is the king, quote unquote, right? So, but just on top of the parliamentary system of government is constitutionalism, such that even though the parliament is, quote unquote, the king in Canada, it is subject to the Constitution of Canada, right? So that is why when we talk about division of powers, the emphasis is on legislative powers, because the legislature in Canada is, superior to the other branches of government. So I was saying that when you think about the Constitution Act 1867, you think about division of powers. And what that simply means, just as it sounds, is that all legislative powers in Canada have been divided between the legislature at the federal government, which is the parliament, and the legislature at the provincial government, which are the provincial legislative assemblies. And I mean, the easiest way to explain that, to explain the whole concept of division of powers to you, is to say that certain subject matters can only be legislated upon by, certain legislative or a particular level of legislature, right? So certain subject matters are competent only to the parliament, the federal legislature, whilst certain other subject matters are competent only to the provinces. And once there is a mismatch somewhere, it means that, that legislative body has acted ultra vires, and by virtue of Section 52 of the Constitution, that legislature would be of no effect, right? It will be null and of no effect. So that's the one-liner and the basest way to explain the entire concept of division of powers, right? There's a whole lot to talk about under that, but just for the purpose of an introduction and an overview, have that at the back of your mind. And then and all of that is, provided for by the Constitution Act 1867. And then Constitution Act 1982 just provides for the charter, right? It provides for charter rights. It provides for Aboriginal, rights. It entrenches Aboriginal rights in the Constitution, elevates Aboriginal rights to have constitutional status. And then it provides for constitutionalism in Canada. Right, so if you have a table, you have Constitution Act 1867, division of powers. Constitution Act 1982, first, charter rights. Second, Aboriginal rights were elevated to have constitutional status. They were entrenched in the Constitution. And then third, it provides for constitutionalism in Canada. It declares and stipulates that Canada will practice constitutionalism. I mean, and that's provided for by Section 52. So the Charter rights, you have Section 1, and then all the other sections that provide for the right. Section 1 introduces the right, provides for the right generally, and provides for how they can be limited or infringed justifiably. And then Sections 2, 7, and a couple of other sections, provide for the rights individually. Aboriginal rights, Section 35 of Constitution Act 1982, and then what's the third one now? Constitutionalism, Section 52, because Section 52 now clearly declares that, all laws or any law that is inconsistent with the Constitution of Canada will be null and of no effect. That there makes Canada, a state that practices constitutionalism and, effectively subjects the Parliament to the Constitution. Before the enactment of the 1982 Constitution, particularly Section 52, the Parliament was pretty much, and of course, before the enactment of the 1982 Constitution, particularly Section 52, and, ignoring the operation of the provisions of Sections 91 and 92 of the Constitution Act 1867, the Parliament was supreme. But for those, two. But the Constitution Act 1982 comes and loudly declares, expressly declares that, Canada practices constitutionalism and all laws, should be consistent with the Constitution. Right? And then there's a whole lot of conversation to have. I mean, that pretty much captures the nature. All you need to know with the nature, for exam purpose, in my opinion, is that it is written, right? But it is not, the Constitution of Canada is written, but it is not contained in one single document. It's spread out in, several documents, some of which are listed in the schedule to the Constitution Act 1982. But very importantly, for the purpose of passing the exams, just zooming on the two Constitution Acts, 1867 and 1982, right? And then there's a whole lot of conversation to have when it comes to the sources. And I would ordinarily skim through it, but I think it's also a fine exam question spot. So I'd advise that you pay attention to it when you study. I have it all prepared in a page and, a bit, right? But just when you start to read, pay attention to it. I mean, not too much attention, but be able to say to yourself before you go to the exam hall that you have at least read through it once, just in case you get a question. Royal prerogative is a good spot to get a question from. Royal prerogative as a source of, constitutional law. At what point are royal prerogative subject to judicial review, right? At what point do they become reviewable by the courts? Right. Another tricky one to pay attention to would be parliamentary privilege. We have established on this call that essentially Canada practices a parliamentary system of government, but for the fact or for the introduction of Section 52 that now introduces constitutionalism. But even at that, right, the Parliament still enjoys certain privileges that are not reviewable by the courts. Certain privileges that are not, subject to even charter rights, right? And, it's just, I mean, the express answer to that one is they are not judicially reviewable. Well, to a large extent, so long as that privilege was exercised in the direct fulfillment or discharge of the function of the Parliament, then they're not subject to judicial review. The courts cannot look into them. And what that really means, judicial review means is, can the court review, look into those actions or, that act or that law for the purpose of determining whether it is constitutional or unconstitutional? That's what judicial review pretty much is. Can the court look into it? I mean, the court is the one, judiciary is the one saddled with the duty or the obligation of judicial review, right? And then once we start to say, is something subject to judicial review or is it not subject to judicial review? What we're saying is that, can the court look into it? Does the court have the jurisdiction, the powers to review that act to say that, okay, we're trying to determine if this is constitutional or not, determine the constitutionality of that act. And the general answer, to have at the back of your mind is that parliamentary privileges are generally not reviewable by the judiciary, so long as they were exercised in the direct discharge or delivery of, the performance of the functions of the parliament. Then they're not judicially reviewable. Now, you need to, I say to candidates that the NCA, the reason the NCAs are a bit tricky is not because, we're all lawyers, we've all written difficult exams, we've all studied bulky materials. So the reason the NCAs are a bit tricky is that, in my opinion, the NCAs are not interested, they're not about testing your knowledge. The focus of the exams is not to test your knowledge. The focus of the exams is to test that your knowledge has now been distilled into understanding, and then even past understanding into what I like to call it internalization. Like, you have read it, you have the knowledge, you have spent some time with it, you understand it, and then you have internalized it. No matter what way or what in whatever form it is flipped, you can identify it, you can fish it out of a multitude of things and single it out and say, this is what this is. And my opinion of that, it's my opinion, it doesn't have to be true for everybody, is that you don't get to those three stages by just reading through the material. You need to spend time with it, right? Or I also advise having conversations. If you decide that you're, uninterested in getting a tutor, getting a paid tutorial where you can go on and have talks, which is what I really believe is the essence of having a tutor. Well, of course, you have the advantage of having the knowledge part as well also shrunken, so you don't have to dive into the entire hogs or the entire 200 and whatever pages of notes that are all over the place, especially with this kind of diet where you have a relatively short time to read and get familiar with it, right? But if you're uninterested in doing that, then just spend good enough time with it. It's not enough to read through once, because when the questions come, you realize that, nobody's going to ask you, what is this, or define this, or how does this work? They're going to flip it out, with the intention of really testing the depth of your understanding and how familiar you are with those concepts, such that you're able to fish it out, analyze it, break it down, regardless of however it is presented, right? So we've touched on the nature of the Constitution, we've touched on sources, and I've highlighted two of those sources to you. There are a number of sources when you start to study, or if you decide to join my paid sessions, we'll review them one after the other. But I highlighted two of those sources to you. I think that they are the most tricky ones that you need to pay attention to if you, choose not to come back to my classes and you choose to study on your own. Pay attention to those royal prerogatives and parliamentary privileges, right? And then we move to the second chapter, right? Does anybody have any questions so far based off of anything I've said? Okay, so we move to, thank you, Divya, I hope I'm saying it right. So we move to the second chapter, amending procedures. With amending procedures, it's one of the topics in constitutional law that candidates get frantic, with. But my advice is always that you don't sweat it, don't stress. Have your sections 38 to 44 printed out, right? Have them printed out. In fact, my advice is have them, or maybe not printed out, but make sure that maybe it's a tab opened on your laptop perpetually throughout the period of your study, right? And then even before you go into the notes or the materials or the textbooks, read them, like read those sections by yourself as a lawyer that you are. The sections are worded very simply, very clearly, very straightforward. Read them. Don't try to memorize them. My advice, just read through a couple of times, and you're good. There's nothing tricky about it. If I start talking to you about it and I start with a 750 rule, I mean, you feel so bamboozled and you're like, what exactly is 750, blah, blah, blah. But if you read through those sections 38, 39, 40, read through them carefully by yourself on your own, right? And then you're good. Then you can go to the materials, to the notes, and just for the purpose of getting more flesh, looking at reviewing cases, judicial authority and all. But my advice, when I really want to help and I'm not trying to, sell my myself and my tutoring skills, is just read the sections, read 38 to 44. I always advise to print it out so you can make notes in your own, handwriting. This is that, this is this. But the most tricky thing with amending procedures, if you do get a question in the exam hall, is understanding your question. It's not anything any tutor is going to teach you. That's the honest truth. It's understanding your question. Because the way the questions come, of course, they're drafted to trip you, to make you think that it's one of the procedures that should apply, whereas it's another. And when you read those sections that are highlighted, please pay special attention to the some but not all rule, some but not all procedure, and the 750 procedure. Excuse me 1 minute, please. Okay, so please pay attention to the 750 rule. Sorry about that. And pay attention to the some but not all rule. It's nothing tricky, trust me. It's nothing tricky. You just need to be mindful when you get a question. When you get the facts of the question, you need to, whilst you're reading through, highlights, this eliminates this rule or this procedure. This eliminates this other procedure. This eliminates this other procedure. And for this reason, this is the procedure that should be applied here. Right? Because when you get those facts, it trips you off. It makes what is not appear to be what it should be. That's the hack with amending procedures. It's not in the sections themselves. It's in you getting familiar with them and you being calm and not nervous or tense in the exam hall, so that you can really read the question and make the right decision as to which of the procedures that would apply. And it's usually a very cheap question because there's not a lot of analysis or analyzing to do when it comes to a question touching on amending procedures. All you need to do is understand the question properly and be able to decipher which of the procedures would apply. And once you do that, what you will be, what you'll be writing in your answer would just be eliminating the other procedures. It's not a 750 rule because it touches on this. It's not this rule because that's it, you have your answer. Right? So with the amending procedures, don't get panicky. Read the sections themselves. Of course, read the textbook, read your materials. But more importantly, when you get to the question in the exam hall and you do realize that you have an amending procedure question, be calm, take a deep breath, and then read through the facts. And that will help you decide which of the five, I think there are five, which of the five procedures should apply. Right? If you ask me, we're good to move. I mean, I have it all summarized in a page and a bit, a page and 4 lines. And then if you do come to my paid classes, what I will pay a lot more attention to would be, as it touches on chapter 2, would be to review a lot of past questions that touch on amending procedures. Because in my opinion, if you understand, generally with the NCAs, if you understand the question, you're most likely good. But with amending procedures, especially, the confusion is in your interpretation or your understanding of the facts of the scenario that you're being given. Right? So we'll move to chapter 3. Chapter 3, I believe, is federalism. Are we working with our syllabus? Can we all reference our syllabus? It's online, nca.legal. You go to outline, you might not see that syllabus. I think it's outline, exam outline, and you just choose or click on Canadian constitutional law, and you'll have it. So the third chapter is federalism. The federalism, the conversation to have is, first of all, the fact that, of course, Canada is a federal state. And of course, all of us on this call have a a general understanding what federalism is about. It just means that the government in the state or in the country is, you know, is divided in not branches. Branches would mean judiciary, executive, and legislature, but in levels, like the levels of government, usually 2 levels of government, a federal and a state government, or a federal and a provincial or regional, government. And then you have the conversation about the status of each level of government, right? I think that very important, you need to avert your mind when you start to read chapter 3 to the status of those levels of government in Canada. A conversation I like to highlight with my candidates is, it was a question I got in my own exam, is the distinctions between, you could write it down, this is a cheat sheet, just in case you don't come back, or maybe I shouldn't share it. But the distinction between classic federalism and Canadian federalism. When you start a study, have that question answered out, even if you don't write it down like, a pre-prepared answer, be able to have that conversation with yourself in your head. The distinction between classic federalism and Canadian federalism, and of course, how that affects, or the implication, the effect of it in, within the constitutional law jurisprudence of Canada. Canadian federalism, classic federalism, its effect, or the effect of it, wholesome, a holistic, review of the effect of Canadian federalism as against classic federalism on the jurisprudence of constitutional law in Canada. Oh, and by the way, if you come to my class, it's a conversation we'll have. It's a question I'll answer for you, right? But if you don't, just, think about it, review it, pay it some mind when you're reading chapter 3. So that on the one hand, you also want to pay attention to the reasons why federalism is a good deal for Canada. An argument for and an argument against, right? Which means that you need to understand a bit of history, how, Canada, the Dominion, and all the other provinces, indicated interest to join in with the Dominion, and, the nuances and peculiarities of those joining in, because, I'm sure a lot of, well, if you don't pay attention when you start a study to the history of particularly Quebec, how Quebec became a part of the Dominion, and a few other of the provinces. You have to have that conversation anyway when you have to review language rights as a charter rights, because when provinces or territories indicated interest to join in the Dominion as provinces, there were a few issues, or issues that came up that didn't cut across board, right? Because we all know that the territories didn't join in all at the same time. It was all at different time. It was like a staggered kind of building or establishing, and certain obligations that were imposed and accepted by certain territories were not imposed or accepted by certain other, quote unquote, not territories, let's use provinces, right? Or rather, let's use territories before they were assimilated and, admitted in as provinces. So that's a conversation you're going to have anyway when you're reviewing language rights, but just be able to reflectively appreciate, how that speaks to Canada's decision to adopt federalism, right? And how it has worked for Canada and how it has worked against it, the pros and cons, the advantages and disadvantages of federalism in Canada. That's 2, right? I've highlighted 2 things that you need to pay attention to in chapter 3. Hopefully you got them. The third is the most important one, which is division of powers, because the whole entire conversation of division of powers in Canadian constitutional law is as a result of the fact that Canada operates federalism, right? Canada is a federal state. So there are 2 levels of government. However, as I've highlighted, the most superior, or the superior branch of government in Canada is the Parliament, is the legislature. And that is why when you're describing federalism in Canada, you're not really, I mean, you're generally saying it's the division of powers between two levels of government. But when you're really zooming in on it as a student of, you know, Canadian constitutional law, you really want to highlight legislative powers, right? The division of legislative powers between the two levels of government in Canada. So those are the three things you want to pay attention to when you're reviewing federalism. With division of power, not in great details, because I mean, division of powers, we're going to talk about in a number of other chapters, right? But just to be able to explain, to understand, and be able to reflect on how federalism is the bedrock and the basis of division of power, division of legislative powers in Canada, right? And then, I mean, I have that all summed up in less than a page. For some reason, I don't feel like you're seeing the documents, but it's fine. Less than a page, because my classes will be, I'm very convinced that we're all lawyers. I mean, even if there's anybody who's taking the NCAs who's not been called to any jurisdiction, called to the bar in any jurisdiction, at the very least, this is not your first. I mean, you already have an undergrad degree at the very least. A lot of us have postgraduate degrees, and also I don't really stress. My opinion is when people come out of the NCAs and they are failed, it's not for lack of knowledge or because they didn't read or understand the materials that they read, right? We're all grown-ups. If 2 weeks before the exam that you have paid for, you realize that my knowledge level is not impressive, you can cancel or defer, right? So for any of us, largely speaking, an NCA candidate to walk into the exam hall and write the exams, it's not because they didn't study. It's not because they didn't understand what they were reading. It usually, in my opinion, is it's usually a defect in understanding of the material, but more importantly, a defect in understanding and interpreting the question. So my sessions will not focus a lot on bulk, like what you're reading, knowledge and all, right? It will focus more on having this conversation so that they're internalized, and then looking at questions, past questions together. I really honestly believe that 55% of your chances at passing the NCAs is based on your ability to understand the questions that you get. Because I also believe that a lot of us come from jurisdictions where our education systems are very knowledge-based. We just want to know that you know it, right? They're just testing your knowledge. What is this? What is that? You know. But in Canada, nobody's going to ask you what is this. Nobody wants to know nobody wants to test your knowledge base. The easiest questions you will get will test your application of the knowledge. And the most tricky questions you will get will test how much you have internalized the concept and how much you're able to critically analyze, the question that you've got, to be able to distinguish and, eliminate, it's not this, it's not that, it's not this, it's this, and zero on it. Because I believe that with all the NCA candidates, if what happens at the NCA exam centers is somebody just comes and says, what is interjurisdictional immunity, we will all give it back to them. Word for word, this is what it is. But it's in being able to understand the question, critically analyze, and then apply your knowledge, display the fact that you have internalized all the information that you took in, that earns you your marks, right? So that will be my focus with my paid classes. So that takes care of chapter 3. I really hope we're able to run through up to, I think, chapter 20 before the time is up. So we go to chapter 4, and chapter 4 is judicial review and principles of interpretation. And again, I will only highlight things that you should be mindful of, right, when you're studying this chapter. This one is a bit bulky. It's not tricky. It's just a bit voluminous. And if you work with me closely, I'll be able to pick out, the things that I consider important here. So the first conversation to have with judicial review and principles of interpretation is, as I said earlier, when we talk about judicial review, once you hear judicial review, what it really just means, the basic way to understand it is that is the court competent, does the court possess jurisdiction to review, to examine, you know, for the purpose of determining the constitutionality or otherwise of either a law or a governmental action, right? So if we're saying judicial review, what we're saying is, does the court possess jurisdiction to examine for the purpose of determining the constitutionality or otherwise of a legislation or a governmental action? And of course, it's a no-brainer. Judicial review is the business of the courts, of the judiciary, right? And then, I mean, there are a lot of things to pay attention to, which is why I will never advise, just so we're clear and I put it out there, I'm not a tutor that will say to you, if you pay me and you come to my class, you won't read, or all you have to read is 4 pages. No, you will read. You will cover your materials. I would advise that you do that. Cover your materials, maybe not the textbooks, but whatever materials that you have decided you want to use, cover it. But like I've said, it's not in just covering the materials, right? That's not what will earn you your marks or help you pass the exams. So I'm not going to say to you, if you come, when I show you that I have it in just a page or two, it's just to say to you that the things I consider important, right, are the things that I've crunched into that. But there's so many other things, especially with chapter 4, that you need to be mindful of, that you need to be able to say to yourself, like I've said before on this call, that I have at least read through this once. It is familiar to me. Right? And then some of those things are, you know, some of the conversations, academic, if you ask, but can be tested in the exams. The conversations that can be had with the role that the court plays in reviewing the enactments and the enactments of the parliament and the actions of the government as a whole, or the other 2 levels of government. In fact, sometimes the other 3 levels of government, including the judiciary, because sometimes the actions and the acts of the judiciary itself is subject to judicial review as well, of course, by a higher court, right? So some of the conversations that we would have will be how there've been academic review conversations and critics, especially criticism, as to how the courts that are unelected somehow eventually in the process of discharging the duty of judicial review end up almost discharging duties or performing functions that should be the exclusive reserve of elected government officials. I got a question like that in my exams. And if you just skim through the course content and do, constitutional law is broken into 2, just understand chapter, understand division of powers, if you have 10 6-mark questions, you know it's a hit or miss. It's either you know it or you don't know it, right? It's either you can say to yourself, I've seen this somewhere before, and you can quickly go back to it, or you just write from your residue. And just before I go on, let me also say that I advise candidates that in as much as the NCAs are an open book exams, and also the fact that with the online administration of the exams, an extra hour has been added, right? It's no longer 3 hours, it's 4 hours. My advice to my candidates is set up your minds to be able to answer the bulk of your question off the top of your head, like the closed book examinations that we're used to, and only have to revert to your materials for specific details, maybe a case, or what exactly is this overlap here? I just want to quickly check, right? But be familiar enough with these concepts that you can go on at least for a page or a page and a half or 2 uninterrupted, just writing from your head. Because the examiners, in my opinion, are able to tell when you are just reproducing an IRAC or something that is just molded, when you're just reproducing a mold, they're able to test the depth of your understanding, right? And then, take that aside, even if you don't take my word for it on that, with the way the questions are coming now in recent diets, a mold won't help you. So imagine you get this kind of question of, what are the drawbacks with the fact that the judiciary as a branch of government is saddled with the responsibility of conducting judicial review, more particularly in view of the, superior status that the parliament enjoys in Canada. Trust me, there's no IRAC for that. You have to write from the depth of your understanding. Do you understand me? if I wasn't drawing your attention to this now, you probably read through your course material and not be able to appreciate that. But if you read through with the mindset of understanding and appreciating this, facts, then when you get a question like that, it's easier for you. It's easier for you to, already have an idea and know where to check to be able to build your response. Because I got a question like that, and that's why I'm very anti IRACs and division of power charter. I got those specific 6-mark questions. We don't need you to write 2 pages. We just need you to tell us, do you know it or you do not know it? And that's it. Do you understand? So when you're studying chapter 4, or if you do come to my paid classes and we're having that conversation, that is a conversation we will have. What's the drawback of all the branches of government? Only the court, of course, can be saddled with the responsibility of reviewing governmental actions. And of course, with the effect of Section 52, somebody has to do that review. That review is important because 52 says if it's inconsistent with the Constitution, then it is null and of no effect. Somebody has to be that umpire to be able to say it is inconsistent with the Constitution, or it is not, or it is consistent with the Constitution. However, there's still drawbacks. There's still areas or sources of concern for, even with that. And then you now need to have a decision or make a decision to say, if you get a critical review question, critically review the roles of the courts, in conducting judicial review and examining the, enactment of Parliament, considering the fact that, Canada is really and essentially a parliamentary system of government, right? You now need to be able to say, oh, this is, what judicial review is, what parliamentary, the role of the Parliament or the status of the Parliament in Canada is vis-a-vis the other branches of government, right? The import of Section 52 and how it becomes essential to be able to judicially review the actions of the Parliament for constitutionality, and then speak to those drawbacks to say, yes, there's been academic conversations to say the court, this power there's a thin line or there's a fine line between the court, reviewing and pretty much enacting legislations, or pretty much, reducing or subtracting from the powers of the Parliament in Canada, right? Establish those drawbacks and then draw a conclusion, either to say the court should be cautioned or their powers should be curtailed, or to say, it's better to have the courts overstep their bounds every now and then than to leave the other arms of government running amok and unchecked. Right, so you decide which. So another thing with the NCAs is that generally, not all the time, sometimes some questions are yes or no. It's either this or that. But generally, the bulk of the questions, it's neither here nor there, particularly with constitutional law. Because if you follow even the decisions of the Supreme Court, we're all waiting. All the constitutional law experts, all the unis are waiting to see what the Supreme Court will hold, what the decision would be, how they would decide the matter, and then eventually when the decision comes, it's usually a very tight split or a very close split, 3 to 4. 4 of the justices thought this way, 3 of the other justices thought that way, right? It's usually very close. So I always tell my candidates, relax. Right, some questions are yes or no, it's either this or it's that, but the bulk of them, it's not really about your conclusion. And more importantly, the marking rubrics for the NCA, the marks are not clustered at the end. The marks are not attached to your conclusion, right? It's spread out. So you start out that you're even able to identify what the appropriate issue with the question, the examiner was trying to highlight in the question, you get some marks for that. So I always tell my candidates, identify issue first. Your first line, just identify the issue. Just say, as basic, as unlawyer-like as that sentence might sound, just write it. Just say the issue triggered in this question is the issue of maybe division of power, or validity as it concerns division of powers, or I highlight that issue because it earns you some marks. The fact that you're able to identify the issue that the examiner was highlighting in that question earns you some marks. And then, of course, I'm not huge on the IRAC thing, right? The NCA recommends it, but I believe it's just a way to express your thoughts, right? So have fun. And I also tell my candidates, don't set up your mind like an NCA candidate. Set up your mind like a justice of the Supreme Court. This legislation has come before you. You need to review it. What would your position be, right? But you can only do that if you're able to confidently tell yourself that you have a good grasp of the concepts. Once you have a good grasp of the concepts, you understand them deeply, you've internalized them, don't go into the exam hall like an NCA student or like an exam candidate. Go into the exam hall like a panel or a justice on a Supreme Court panel who's really trying to review this legislation and confidently and intelligently defend your position or your conclusion, right? So yes, identify your issue, do your analysis whilst highlighting the rule or whatever you want to apply. Do your analysis. It's not this because it's that. It's this because it's not that. And it has to be this because it's this, right? Especially as held in this case, right? And then draw your conclusion and you're good. So even if your conclusion is not spot on, you would have earned, you know, your 2, 1, 2 marks, 2, 1, 1 mark, 3 marks, 1 mark, all around your submission, right? Before you get to the conclusion. Right, but I digress. So we're talking about chapter 4, and I highlighted an issue for you to pay attention to when you're reading, and that's, in my opinion, the bulk of the conversation to have when it comes to judicial review. Well, maybe not the bulk of the conversation, but the place to start your conversation from. That's the reason we're talking about judicial review. The fact that, you know, Section 52 provides that acts of the government and legislations enacted by the government or the parliament and legislative assemblies should be consistent with the Constitution. Somebody needs to ensure and monitor that these legislations are actually consistent with the Constitution, right? And if they're not, somebody needs to say, oh, no, foul, error, this is not constitutional, and for that reason or for that, you know, purpose, it is null. And the person who does that in Canada, and I mean, just logically, would be the judiciary, the courts, right? That's where you start that conversation from. Now, in conducting a judicial review of either a legislation or a governmental action, it's important that I say to you, I hope it doesn't confuse you, that when you talk about conducting judicial review of a legislation and a judicial action, it could be on both grounds, which is division of powers. Some people call it federal grounds, or charter grounds, right? But you also need to pay attention to the fact that it's more likely that a court is reviewing a legislation on federal grounds than a governmental action. Did you get that? It's more likely that a judicial review on federal grounds is in respect of a legislation than a governmental action. It's more likely. Unlike the charter rights, it's more likely that it's a governmental action that has infringed on your charter rights, you know, than a legislation. And that's not to say that legislations also don't get reviewed for, you know, consistency with the charter, but it's not likely that a governmental agent or official who, you know, believes that a legislation empowers him to carry out an action has carried out that action, and that action has infringed or breached your charter right, right? It's okay if you don't totally get it, but just take it in when you start to study. Even if you don't study with me, you will remember, it will come to life and you'll be able to file it properly when you start to read. But just have that at the back of your mind, right? So we've established judicial review, the need for it, the justification for it, right? The need for judicial review and the justification for judicial review, and, you know, the body who started with the responsibility of conducting judicial review. Now that takes us to the principles of interpretation. I mean, chapter 4 is judicial review and principles of interpretation, right? So in conducting judicial review of, let's use a legislation, because, I mean, there's nothing to interpret about an action. It's usually a legislation that needs to be interpreted, right? In conducting judicial review of a legislation, the courts, of course, need to break that legislation down, right, and interpret it. I mean, we're all familiar with the concept of statutory interpretation, and we're all familiar with the fact that it's the business of the court to conduct statutory interpretation of, you know, a legislation or a document, right? And that's just what this is, what chapter 4 is talking about. Establishes first the need and the justification for judicial review, and then goes into principles that the courts have over time in the jurisprudence laid down and established and followed to aid the courts in interpreting a legislation for the purpose of reviewing that legislation to determine the constitutionality or otherwise of that legislation. Am I talking too fast? Do you guys get me? Okay, so judicial review we've established, and then what the court does in reviewing a legislation is to interpret the legislation to determine if it's constitutional or not. Now, over time, the courts have created, of course, we recognize that Canada practices, or rather, okay, let's take that back. The bulk of the provinces in Canada are common law based, except for Quebec, that is a civil law, that runs a civil law system, right? So the bulk of the provinces in Canada operates a common law system, and we understand that with common law systems, the judiciary is that powerful to, you know, create, develop new, unheard of principles that they give the force of law to, you know, and rely on subsequently to help them with, you know, similar transactions or similar matters, right? That's the entire concept of judicial precedent, right? Which you shouldn't bug your head with for constitutional law. I mean, you might need to bug your head for that with foundations if you're taking foundations, but you don't have to bug yourself with that for the purpose of constitutional. Just have that understanding and then bring that to the table here. That's the conversation with principles of interpretation, right? That's the reason for that. Now, I'll get into a bit of it and then we'll move. So once you talk about judicial review, I've established that the courts conduct judicial review on two grounds, either on division of power grounds, federal grounds, which is provided for by the Constitution Act. Somebody wants to tell me which of the Constitution Act provides for division of powers? Somebody, anybody? Which of the acts? We've identified two acts, and I've identified which provides for, you know,
1867.
1867. Fantastic. Fantastic. Thank you so much. Because for a bit, I felt like a radio who was just going on and on. It's good to hear your voice, right? Yes. So we've established the judicial review can be conducted, or the two bases or two grounds for which to apply to the courts to review a legislation or an action, right? The first is division of powers, which is provided for by more particularly sections 91 and 92 of the Constitution Act 1867. And, you know, charter grounds, which is provided for by a number of sections in the Constitution Act 1982, right? The basis for judicial review as far as constitutional law is concerned. Now, in doing that, I've also established that the court needs to, particularly particularly as touching the division of power grounds, the federal grounds, the court needs to interpret the legislation. And in doing that, the court has created and established a number of principles that assist the courts in interpreting the legislation for the purpose of determining its constitutionality. So amongst those principles, you touch on the pith and substance doctrine. You touch on singling out, you touch on interjurisdictional immunity, you touch on purpose effect, you touch on purpose, you touch on effect, you touch on colorability, you know, and a couple of others. And the way I like for my candidates to shelf it, because the word in town, you know, when I listen to other tutors, is that there's been like a mysterious effect, you know, that have been assigned to a few of these doctrines. But I don't like my candidates to see them that way. See all these doctrines as just principles of interpretation, things that the courts have, principles or doctrines that the court have established to help them decide the constitutionality of a legislation, right? And when you talk about the pith and substance doctrine, I'll go into that really quickly, right? Just so you see what I mean. When a court has to, I need your attention for this one. If there's anything you find you want to note down, let me know and I'll go over it. But I need you to get this, because with this concept, if you get it the first time, it's easier for you to just develop on it, right? When the court is saddled with the responsibility of conducting a judicial review on the grounds of division of powers, so there's an application, an applicant has gone to approach the court to say, this law says this, right? And I'm not comfortable with it. I don't believe it is constitutional. So please review it and let's know what you think. The process, the process that the court will embark on to conduct that judicial review is two-staged. Take note, we're discussing judicial review on federal grounds, on division of power grounds. Two-staged. Characterization, stage 1, and assignment, stage 2. Characterization, stage 1, assignment, stage 2. With characterization, a lot of these principles of interpretation come to play. Because, I mean, just as it sounds, characterization, all that it is, nothing spooky, nothing clumsy, all that goes on at that first stage is that the court is trying to determine the character of the law. As it sounds, characterization, characterize the law, determine the character of the law. And that should immediately suggest to you that it means that legislations can have different characters, right? It means that the legislation can appear to be this and that and this and that, and the court, because if it's a no-brainer, then there will be no need to conduct a review, right? It would just be, okay, tell me what's the name of the law, or Banking Act 1992, and that means the character of the law is banking. But what that tells you, if the court is going to devote some time to it, it tells you that sometimes it's not as easy as it appears. The fact that it's called Taxation Act 1992 doesn't mean it really, if you conduct a review of it, the character of that legislation will really be taxation. It should be, but it might not be. Right? So what the court does is reviews the legislation, looks into it, but intrinsically, excuse me, I feel like I need to take out this virtual background because just 1 minute, guys. Just a minute, I apologize. Can you see me now? Yes, okay. So what the court does is, in characterizing a law, the court reviews the legislation intrinsically and extrinsically. Intrinsically to mean the court reviews everything in the document, the title, the preface, the introduction, the sections, all the provisions, right? And then also admits extrinsic evidence. So, I mean, I'm looking. I need to explain to you in the basest way. If you have a child, if you have kids, and maybe you buy a storybook, a new storybook for your son or your daughter, and then you even haven't read it. I mean, maybe the title of the book is Butterflies or something, butterflies, right? And you bought it for your son, and then your son is trying to read it and comes to meet you to say, I really don't get what the real deal, or what exactly this book is talking about. Now, you might be tempted to say, oh, the title is Butterflies, so it must be talking about butterflies, right? But if you sit down and you read the book, you're able to say, okay, maybe it not just talks about butterflies, it talks about insects generally. Do you see that? You have characterized the book. And that's what the court does. Looks at the document, the legislation in its entirety, right? But also admits extrinsic evidence, evidence outside of the document. Evidence outside of the document. So you have things like you have things like evidence of the legislative history of the legislation. What was the mischief that the Legislative Assembly or the Parliament identified that now informed the decision to enact that legislation, right? That will also help you determine what exactly that legislation is about. And then when you have questions in the NCA that touch on division of powers, you always have those extrinsic evidence. You see things like, so the premier of the province, went on the news and said, this is such an issue within the province. It's becoming uncontrollable. It's such a mess. And for that reason, we're going to rise up to the challenge. All that is also admissible. And when I say admissible, remember I said to you, set up your mind as a justice of the Supreme Court. Do not set up your mind as an NCA candidate. So look into all that extrinsic evidence as well to help you determine what exactly, the Parliament was trying to achieve with that legislation. And so that's the conversation with characterization. And in characterization, you talk about pith and substance doctrine. The pith and substance just means that what is the substance? What is the core? What is the most prominent feature? Right? What is the most obvious character, the most holistic identifier of that law? Right? When you start to read, I'm imagining or I'm guessing that a lot of you on this call haven't really started to read in great details or in great depth. But when you start to read, these things, what I'm saying to you, will come alive, and it'll be easy. It'll make it easier for you to understand. And if you do come to my class, I mean, we will break it down into great details. Review all the case laws, because the case laws are very important when you're reading this, when you're studying division of powers and charter rights. That's another priceless advice that I should charge you guys for. Do not read just the one lines that you will find in the notes or in the well, if you're reading the textbooks, you had a good view of the case. Do not read just the one lines and the summaries you find in the notes or in the materials. Go out of your way to get the facts of the case. Of course, I do not mean read the entire Supreme Court judgment that will be about 30 pages, but familiarize yourself with the facts. So I'll give you one off the top of my head. One of the case laws that are very important when you have the conversation of characterization for the purpose of determining the validity of a law on federal grounds. And it's I believe it's the Alberta Bank taxation reference, right? So the province of Alberta had enacted a legislation. And, you know, I'd called it, I believe that the title of the legislation was the Taxation Act, right? Alberta Taxation Act. And then the legislation had taxed all businesses across border. I hope I'm not mixing the facts, you know, with another case. The legislation had imposed taxes on all the businesses in Alberta, but imposed a slightly higher, you know, rate or amount on banks within Alberta, right? And then the banks had applied to the court challenging the validity of that legislation. And in determining the character of that law, you know, having reviewed both intrinsic and extrinsic evidence rather, the court held that truthfully we agree that, you know, the most prominent character of this legislation is with respect to taxation, right? We also see that there's a slightly higher rate imposed on banks as against other businesses, but we agree that this is for the purpose of increasing revenue or generating revenue for the provinces, and it is within, you know, the powers or the competence of a province, of the legislative assembly of a province, to actually do that, to generate, to tax, to generate revenue for the province. And so we find, or we hold, that this legislation is constitutional. Now, a sharp contrast would be the case of Lambert and Bank of Toronto, right? Where a province that also enacted a legislation taxing or imposing taxes on banks. However, after the court reviewed, you know, that legislation, the court found that that particular legislation imposed taxes, or rather the character or the intention, the legislative intent with that particular legislation was directed solely at banks, right? And the court held that, and I mean, once you review your 91 and 92, which is why I say, have it printed out. If you take my advice, have it printed out. Once you review 91 and 92, you will find that banking falls under 91, which is for the Parliament, right? Which 91 lists out the subjects that are competent to the Parliament, 92 lists out the subject matters that are competent to the province, and you find banking under section 91. And what that just means is that if a subject matter is under 91, the provinces should not be enacting legislations in respect of that subject matter. And vice versa, if it's under 92, the Parliament should not be enacting legislations in respect of that subject matter. And so in Bank of Toronto and Lambert, I believe, except I've mixed up the cases, the court held that whilst on the face of it, the legislation appeared to, you know, be in respect of taxation, but upon judicial review and characterization particularly, it appeared to the court was of the opinion that the legislation was aimed more at banking than taxation. And so the court held that the legislation was not constitutional, was not competent to the province that enacted it because it was in respect of banking. I mean, I just got into that. I didn't intend to go into that, but I just got into that to hopefully convince you guys that it is essential that you review your case laws. Don't just take the one lines. Review the facts. I mean, I'm not asking that you go read the 5 or 7 pages, but look for the facts, look for the reasons, look for look for a summary that highlights the reasoning of the courts. It will help your understanding. And you will find, in my opinion, I find that a lot of the problem questions you get, the facts you get, particularly with the charter, maybe not with division of power, because with division of powers, the NC examiners get very creative and they can just come up with any set of facts. But with the charter, you find that if you reviewed your case laws properly, once you read your question, a case law comes to mind. Once you start to read the question, it starts to look like, this particular case. This was what happened in this case as well, right? And usually that's the case the examiner is also waiting for you to highlight. So you see how having that organic approach to studying constitutional law is certainly way better than having a mold, right? It might require that, it certainly requires that you put in a bit more work than, having somebody say, just go and write this in the exam hall. But eventually you're more confident and there's almost no way you fail the exams, trust me. More importantly, I know at this stage, everybody's about passing the exams. More importantly, once you pass that exam, anybody wakes you up from sleep the next day, you're able to have that conversation again off the top of your head without referring to any books or materials. I know that might not be of serious importance to you. All you just want to do is pass your exams. But I'm saying there's an easier way and a more assured way of doing it, especially in view of the fact that the NCAs, in my opinion, are changing their style with question patterns, right? Okay, so under principles of judicial interpretation, we have the conversation about interjurisdictional immunity. We have the conversation about the Pith and Substance Doctrine. We have the conversation about colorability. Colorability is just, a provincial, a legislative body trying to do indirectly what it cannot do directly. So you have seen clearly that, for instance, your provincial legislative assembly, this subject matter is not competent to you. It's not listed under 92, but you still want to do it either because you feel like the parliament is being slack, or just not paying enough attention to that issue and it's affecting your province. So you decide to still go ahead and enact a legislation in respect of that subject matter anyway. And then you present it, in a way as though the legislation is in relation to a subject matter listed under 92. That's colorability, right? And it's in characterizing a legislation that the court is able, which pretty much is also what happened in Bank of Toronto and Lambert. The province colorably presented the legislation to be in respect of taxation. But upon the court's closer look and closer examination, the court determined or discovered that it wasn't really in respect of taxation, it was in respect of banking, right? There's an easier way to approach it. I really hope much more than anything that I'm able to demystify this course to you. And either of two things, chase you to the website to register for my class or chase you to your book and be excited to study, be excited to read it, right? So those are the conversations we'll have with respect to chapter 4. Chapter 4 has taken a bit of my time, but yeah, it's expected. It's a bit bulky. Even I, in just trying to distill what I considered important things, ended up having about 4 to 5 pages just for chapter 4. But we will cover some of the most important and confusing or tricky concepts in constitutional law under chapter 4. Now we move to chapter 5. Chapter 5 is federal paramounting, and I have that in less than half a page, right? Okay, maybe not less, just about half a page, right? And the conversation with paramounting, I'll do a backtrack real quickly just to be able to substantiate paramounting for you. And the backtrack is that when we're having a conversation about division of power, judicial review on the grounds of division of power, the constitutional challenge can take 3 forms. It can be a constitutional challenge to the validity of a legislation, which is the conversation we've had about characterization and assignment. Validity just means, is this law valid? Was it enacted by the legislative body that should have enacted it? And the way to do that is the conversation we've had, characterize and assign. And I've given you 2 case laws and try to explain it to you. If it's in respect of banking, if the legislation is in respect of banking, then it should only be enacted by the parliament because banking is only competent to the parliament. If a province enacts a legislation in respect of banking, then it is invalid. That's the word, that's the expression, it is invalid, right? And hence it is not constitutional, unconstitutional. So it is null and of no effect pursuant to section 52, right? If the parliament enacts a legislation with respect to taxation to a large extent, right, then it will be incompetent, it will be invalid as well and unconstitutional, right, to a large extent because taxation can be competent to both heads, or rather to both legislative bodies, right? So that's conversation with validity. You're just determining if the legislative body that enacted the legislation is the appropriate body to have enacted that legislation, considering the subject matter of the legislation and against the backdrop of sections 91 and 92 of the Constitution Act 1867. So the first form a constitutional challenge can take to a constitutional challenge to a legislation on the grounds of division of power will be validity. The second one is applicability. And let me also backtrack. When you're talking about validity, think about peace and substance doctrine, because that's the most important doctrine that will help you characterize a legislation, right? There are a number of others, but peace and substance more importantly, right? And then the second form will be applicability. When you're talking applicability, that's where we have the conversation of interjurisdictional immunity and all of that. The third will be operability. And operability just says, we agree that this law is valid. It was enacted by the appropriate legislative body, right? Pursuant to 91 and 92 is valid, we see. However, how operable should it be? And the reason you have that confusion or you have anybody ask that question is where there are two legislations in respect of the same subject matter, both legislations enacted by the two, different legislative bodies, one by the Parliament, one by Provincial Legislative Assembly, and there is a contradiction, right? So, remember the conversation or the question, well, not question, conversation I advised that you have about the distinction between classic federalism and Canadian federalism. It will come to play very seriously with federal paramountcy, because you're asking yourself, with federalism in Canada and the division of powers contained in sections 91 and 92, one of the features is exclusivity. The fact that if it's contained in 92, it's exclusively, competence to only the province. And if it's contained under sections 91, it's exclusively competence to only the Parliament. However, how is it possible, despite that exclusivity, that there's certain subject matters that both bodies can validly legislate in respect of? Right? That's a question you want to note when you're reading. You try to answer it, or you come to my class and I answer it for you, right? So there's certain subject matters that both levels of legislative assemblies can legislate in respect of, and so you can have two validly enacted legislations, one enacted by the Parliament, one enacted by a province, in respect of the same subject matter, and it's okay. If there are no inconsistencies, what the court will hold is, go, faithful servant, and comply with both. That was what the court held in Rothman's Benson Edges, right? However, where there's a contradiction and it's impossible to comply with both, right? Maybe for example, the provincial legislation says you catch a man stealing, you kill him. The federal one says you catch a man stealing, don't kill him. Now we've caught a man stealing. What do? Federal says kill, provincial says don't kill. You were all clear that the death sentence has been abolished in Canada since, I think, 1870 something or 1970 something. So this is just an example, right? Just for the purpose of this conversation, just to clearly demonstrate what that, how operability comes into the conversation. One legislation says, do it. Another legislation says, don't do it. And you're stuck. If you do it, you would have contravened the one that says don't do it. If you don't do it, you would have contravened the one that says do it. Then that triggers the conversation of federal paramountcy. And just as it sounds, federal paramountcy, it means that the federal is paramount. Ife, are you good? It means that the legislation enacted by the federal government, by the Parliament, will be paramount, would take priority over the one that was enacted by the province, even though both are originally and essentially valid. Don't stress too much. If you can take notes, take notes. But if it doesn't fall into place for you, it's okay, because it's not as if you've read through, or has anybody on this call read through the syllabus at least once? Oh, yes. Oh, yes. I see Divya, and I see Hamid. Is that your name? Yes. Right. So if you can say to yourself you've read through at least once and these things I'm saying don't add up for you, then there's a problem. So Divya and Hamid, right? But if you haven't read through at least once, it's okay. We're only planting the seed. By the time you start to read or you come to my class, right, it will come alive. It will jump at you. You will remember that, oh, this sounds familiar. This was this person was saying, right? It's just, I find it's better to have these conversations, especially because they're free. I mean, these introductory classes are free. Come sit in, just be in that space so that when you walk into the bulky materials, you don't feel too overwhelmed or too confused, and then you run back out. Because when I started to study for constitutional law, believe it or not, I closed it, went back to it, closed it, went back to it a number of times before I eventually got into the mood, right? So that wraps up the conversation on chapter 5. And I think I've shown you, but let me show you one more time. I have it all summed up in, less than a page. And then we'll review the case laws. Very important that you, for Divya and Hamed, if you cannot tell me the fact of Rothman's bending edges right now off the top of your head, just unmute your mics and tell me, then there's a problem. That's my honest opinion, right? And see the way I told you the fact of the Better Taxation Bank reference. I didn't go into the very great details. Just have an idea, let it be familiar so that you get a similar fact-based scenario and it jumps at you. This was what happened in that case and this was what the court held, right? Okay, hopefully we're able to, now I'm going to have to run with the speed of light because we have less than 30 minutes left. So for chapters 6, 7, let me just go into the syllabus. For chapters 6, 7, 8, 9, yes, 6, 7, 8, 9, pretty much. And if you ask me 10 and 11 as well, right? Do we all have our syllabus? Can we see these chapters I'm referencing? 6, 7, 8, 9, and to a large extent, 10 and 11. There's a bulk of conversation to have, right? Particularly with 6 and 7, right? But the way to understand it, because I find that candidates don't understand, the reason the syllabus is laid out that way. And I agree. Eventually when somebody spoke with me and broke it down to me in the source of the confusion, I agreed. Maybe the syllabus should have been, I'm not on the NCA, more with the NCA body, but maybe the syllabus should have been restructured to introduce 6, 7, 8, 9, 10, 11 first, before the entire conversation about division of powers. Because what 6, 7, 8, 9, 10, and 11, if you ask me, they're just heads of powers that the syllabus or NCA considered important to highlight of all the subject matters that were listed in 91 and 92, right? A few were highlighted just with the charter rights as well. Of all the many charter rights contained in the Constitution, a few were highlighted as the ones that the NCA is interested in candidates underscoring and being familiar with, right? So what 6 to, if you like, 9 or 6 to 11 are just a few of those heads of powers that the NCA has decided for us to understudy. Remember that when I talked about the conversation or the process of analysis that the court went back on, in a bid to conduct judicial review of a legislation, I said it was 2 prongs: characterization and assignment. With characterization, you almost don't have a business with the Constitution. All that you're doing, as I've said to you guys, we're all justices on the panel of the Supreme Court, in our heads at least. All the court does is review the legislation itself, intrinsically and extrinsically, like evidence surrounding or relevant to that document itself, to that legislation itself, for characterization. There is no reason yet to consult the Constitution for the purpose of determining whether it falls under 91 and 92. All you're trying to identify or decipher is what exactly is this document talking about? What exactly is this legislation talking about? Character. Now, once you determine the character, it usually is a subject matter. It's usually, this legislation is in relation to banking, like the examples I gave, the case laws we talked about. It's in relation to healthcare. It's in relation to taxes, right? So when you have that, until that first stage is done, you don't proceed to, consult the Constitution. Once you've highlighted that, then you go to the stage of assignment. And what assignment is now you've decided or determined the character of the law. You want to, do a matching, right? Now you've identified the character. Where does this character fall? Under 91 and 92. Assign it under 91 and 92, right? Sometimes it's as straightforward as that. If the decision of the Supreme Court eventually as a consensus characterization is, for instance, the character of this legislation is banking. Once you open 91 and 92, you see banking clearly written out under 91. So you say, yes, the proper place to assign it is 91, section 91. And that means that the proper legislative body to enact a legislation in respect of this banking is the Parliament. Sometimes it's not that clear. You determine the character of the legislation, and you go to 91 and 92 and you don't find it listed out anywhere. Because certainly 91 and 92 can certainly not be exhaustive. And they are certainly not exhaustive. So you determine, for instance, you determine that, okay, I was going to say labor. Yeah, I think labor works. You determine that the subject of this the character or the subject matter of this legislation is in respect to labor, is in respect to employment relations between an employer and an employee. Right? That's the subject matter of this legislation. I'm almost sure, pretty sure, if you go to 91 and 92, you won't find labor relations as a subject matter. Right? What you will see is PCR, property and civil rights. And the reason it becomes important to underscore section 6 to 11, chapter 6 to 11, is that you need to have an in-depth understanding of these subject heads. Because, in these subject heads, over time in the jurisprudence, the courts have made, a number of decisions that have expanded, and made it easier to identify and determine the exact, meaning of this subject head and what this subject matter, or rather this subject head that is expressly captured in section 92, for instance, will include and what it will not include. So if you're, for instance, a justice on the panel of the Supreme Court, just that this time you're not sitting in the Supreme Court's complex in Ottawa. You are sitting in the NCA exam hall, right? And then you determine that the character of the legislation, like I've said, is labor relations. Now you've characterized your law and you're excited to go and assign. You go under sections 91 and 92, you don't find labor anywhere. You're confused and stuck. Right? But if you have underscored the property and civil rights, for example, head of power, you will know that, over time and with a lot of decided cases on the strength or the authority of case law, the courts have held that labor relations are captured under property and civil rights. So that makes your assignments easy. So even though you're not seeing labor on the face of the Constitution, from your study and from the fact that decided case law as the court has interpreted property and civil rights as a head of power to include a number of things, right? To include a number of things that include insurance within the province, business in general within the province, professions and trades within the province, labor relations, marketing, that all of those, on the strength of case law have been interpreted to be included under property and civil rights as a head of power. Have I confused you guys? It's okay if it doesn't make all the sense, but does it make a bit of sense? And that's the reason why we have to understand. So that's why I say that if I were, if I worked with the NCA and they asked my opinion, I would say let's reorder, let's restructure the syllabus. Let's review the heads of powers first, and then go and learn how to characterize and conduct a judicial review. Let's not do the judicial review first before we start to examine the heads of powers. But that's the way the syllabus has it. You learn to conduct a judicial review first, then you learn the expansive nature of these heads of powers. What can be included in this head? What cannot be included in this head? So that's the way to approach your study of chapter 6, 7, 8, 9, and to a large extent, that's debatable, 10 and 11. So when you start to study Chapter 6, Property and Civil Rights, or you pay attention, I cannot emphasize it enough, pay attention to case laws. So that for every of those subjects that you characterize, you have a case law that tells you that the courts have held that this falls under trade and commerce. The courts have held that this falls under property right, property and civil rights. The courts have held that this is a criminal law, matter, and so it should come under the criminal law head of power. And of course, it goes without saying, of course, identify which body or which legislative assembly is competent to which head of power. So when you're underscoring 6, of course, 6 is PCR, and that's for the provinces. When you're underscoring Chapter 7 is trade and commerce, of course, that's for the Parliament under Section 91. Which is why, if you still don't believe me, you need to print out your 91 and 92, right? You need to print out your sections 91 and 92 of the Constitution Act 1867. So by the time you're underscoring, we've identified PCR as provincial, identified trade and commerce as Parliament, identified criminal law as Parliament, POGG as Parliament, but more importantly, we now delve into the depth of it. What will constitute POGG and what cannot be validly filed as POGG? What will constitute trade and commerce and what cannot be, assigned to trade and commerce, right? Very important if you're going to be able to, conduct an analysis and a judicial review analysis of a legislation, whether for the purpose of knowledge, for just, for your own sake, or for the purpose of passing your NC exams. So I hope that, it's a bit clearer once you start to underscore 6, 7, 8, 9. Just know that what you're looking out for is what will constitute this head of power. Because you can characterize a law and you're not coming out to say, oh, there's absolutely no way you characterize a law as being in relation to employment or labor matters. And you will go to 91 and 92 and you will not be stuck because you will not find employment matters under 91 and 92. Divya, did you find employment matters under 91 and 92 in your study? All right. Hamid.
No.
Did you find marketing under 91 and 92? Marketing.
I haven't added studying. I've just done the syllabus.
You haven't what?
I haven't actually started reading through the material. I've just gone through the syllabus.
Oh, you just went through the chapters. Oh, I thought you said you had read through. Okay, no, my question was, have you gone through the syllabus? Oh, I meant the content, the course content itself.
Yeah.
At least once. But Divya has, right?
I have to sort of a mild extent, yes, like one brief reading I have. Yeah.
Yes. And did you find marketing on the sections?
No, not as a word as such, no.
Yes. So you need to understand those heads of powers so that when you see trade and commerce, you know the things that come under trade and commerce. When you see property and civil rights, you know the things that come under property and civil rights. So that helps you with your assignment after you have properly characterized. Right? Are we good? Okay, so that pretty much is the way to set up your mind approaching 6, 7, 8, 9. It's nothing spooky. It's just to really understand those heads of powers so that when you characterize and identify a subject matter, you know what falls under where. And you know that, no matter how tricky the question is, there's absolutely no way labor matters will fall under will be competent to the Parliament, except it's in respect of a federally incorporated company. I do not want to confuse you, but pay attention to those, right? Or better still, come to my class, right? So even though we've established that labor matters are in relation to provincial or competence to the provinces, and you know that there's absolutely no way a legislation enacted by the Parliament will be valid if it is in relation to labor matters, if it's in relation to employment, you also need to be mindful that if it's a federally incorporated company, for the purpose of knowledge, not necessarily for the purpose of the NCAs, for the purpose of knowledge, in Canada, if you choose to incorporate a company, you can incorporate it on both levels or on either levels. You can incorporate it provincially, of which the effect of that would be that you'll be bound by only provincial laws, right? Or you can incorporate it federally. If you incorporate it provincially, it pretty much means that your operations are to a very large extent restricted within that province. If you intend to transact business with that company or in that business name in another province, you probably need to go and register or get some licenses and permissions from that other province. So what I'm saying is, if you incorporate in Ontario and you decide you want to expand or start transacting business in Alberta, you need to go and incorporate in Alberta as well, or get some permissions or some licenses. Now, for the purpose of our conversation, if my Ontario incorporated company has employment issues, it certainly is a provincial legislation that can speak to those, right? But if I chose, knowing that my business will, I'll give you a minute. So, do you have a question, or do you want me to say something again? Okay. If I choose to incorporate my company from the start as a federally incorporated company, then on the pro, on the advantage, or one of the benefits is that I can transact business in whatever province I want, right? Because my incorporation is Canada-wide. But in the context of Canadian constitutional law, and as a con, well, depending on what side of the divide you find yourself, provincial labor laws might not apply to you, or they will only apply to you to some extent. Right? To some extent. And that triggers the conversation of interjurisdictional immunity. Because with federally constituted bodies, whether companies or undertakings, just as it sounds, interjurisdictional. Inter means two or more. When we say international, it means two or more nations. When we say interjurisdictional, it means two or more jurisdictions. In this case, it's just two jurisdictions. It's either federal or provincial. So when we say interjurisdictional, it means that by your very inherent nature as a body, you are caught between both jurisdictions. Divya, you're nodding your head too fervently. You're making me feel like you don't need my classes. You need my classes. Right? But it's very impressive that you've read through to an extent. Very impressive. Very impressive. So inter means, were you going to say something, Divya? Okay. Inter means you're caught between both jurisdictions, because essentially you're federally registered or federally constituted or federally incorporated. You're first and foremost answerable to the federal government, to the parliament. But no matter how federally constituted you are, you will, transact your business from a province or from some provinces, because Canada as a dominion doesn't have any land space. Right? Does Canada as a dominion have any land space? No, it's just a combination of different provinces. So you're either in Alberta or in Ontario or in BC, but you're in Canada. So if you're a federally constituted body, you're answerable first to the federal government, but you must have your base in some province. So it means you're caught between both jurisdictions. And what to know is that essentially and primarily, you're answerable first to the federal government, but in some cases and to some extent, you are also bound by provincial authorities. Right? Let that breathe. Let that just register somewhere in your subconscious when you start to study, or when you come to my class, we will unpack it and unbundle it. Right? So those are that's the way to approach chapter 6, 7, 8, 9. 8, 9, so that you're not just wondering what have all this got to do with anything. That's the way to shelf it. That's just me trying to put some structure and organization to your study, right? Now, when we go to language rights, which is chapter 10, my opinion is there's not much to sweat about. It's not chapter 10. This is probably the first time I'm telling you that something is not an NCA question spot. Chapter 10 is not a common NCA question spot, and there's not much to it, right? I have it in less than half a page, what I consider important. It's good to know for the purpose of knowledge, right? And you never can tell with the way the NCAs are going now. You just might get a question on it, but it's not a question spot, a common question spot. And even if you get a question with regards to language rights, it most likely will be intertwined in a larger body of question. It's not likely you get a language right question that's 20 marks or 15 marks. It might just be, a sub question in a bigger question, if you do. And all you need to pay attention to when you're studying language, right, like I said earlier, is pay attention to the history of a lot of the provinces when they were joining into the Dominion. Which provinces, you know, indicated or accepted obligations that touch on languages, right? Which provinces don't have such obligations? What is the status of these obligations? Are they just mere legislative? Do they just have mere legislative status or constitutional status? I hope you get the difference, you know, the operation between something having just a legislative status and having a constitutional status, especially in a state that practices constitutionalism, right? So pay attention to that. What's the status? What status do these obligations take on? Are they constitutional? Are they legislative? Right? What's the impact of these obligations? Right? And then, I mean, that's on the province and federal level. And then on the individual level, all you need to pay attention to, in my opinion, is that, you know, certain individuals, if you're depending on what province you are in, I mean, if you're a resident of a province like Quebec that has a French majority, a French-speaking majority, and for some reason you belong to the English-speaking minority, right? Do you have any constitutional protections? You know, does the government of Quebec owe you certain duties, certain obligations, right? If I'm a resident of Quebec, I speak English, I don't speak French, I will certainly be in the minority. You know, what benefits or what duties does the government of Quebec owe me, especially as it concerns, you know, my minority language, the fact that I belong to, you know, the minority, or well, yeah, a minority group that is based on language. And vice versa, if you're in Alberta or BC or something, where, you know, you have an English-speaking majority, what are the governmental duties or obligations owed you as a French-speaking minority? Those are the two things to pay attention to when it comes to language rights. First, on the level of the provinces and the federal government, you know, especially as it dates back to the history, pay attention to the Manitoba language rights reference, it's case law. Pay attention to the Quebec, Ford and Quebec and Blake cases, right? And then on the individual level, just pay attention to, you know, the entitlements or the benefits that minority language speakers in a province are entitled or should have access to, right, when you're studying. And that's that with language, right? Are we good? Any questions? I need to wrap up. We have just about 5 minutes left, but I will try to touch on all the and with Aboriginal Rights and Interest, Chapter 11, pay attention to Aboriginal rights, Aboriginal titles, treaty rights, 3 things, and the 4th things, duty to consult and accommodate. 3 things: Aboriginal rights, Aboriginal titles, treaty rights, duty to consult and accommodate. Bearing in mind at all times the provisions of sections 35, sub 1 and sub 2, or sub A and sub B of the Constitution Act 1982, as well as the provisions of sections 33 of the Constitution Act 1982. Right? Did you get that? Sections 35 of the Constitution and sections 33 of the Constitution. And then pay attention to Aboriginal rights, pay attention to Aboriginal title, treaty rights, duty to consult, and duty to accommodate. Those are the things you need to pay attention to when you're studying. Because when you open Aboriginal rights in the textbooks or in the materials, you probably have about 20 or 10 or something pages, right? But if you're able to zoom your study in on those 4 subheads, having those 2 sections of the Constitution at the back of your mind, it shapes your conversation, and trust me, you'll be good with Aboriginal Rights, chapter 11. Chapter 12, interpreting the Charter of Rights and Freedoms. Just as we spoke about interpreting principle of interpretation when it comes to division of powers grounds, right? Federal grounds. You also have certain things that the court has, certain principles that the courts have established when it comes to interpreting charter rights. Remember I said a judicial review, and that's why a lot of tutors break constitutional law down into division of powers and charter rights, because those are like the two major subheads. I'm just saying be wary of doing that, because with the NCAs now changing their question patterns, they're zooming in on other things that we could consider unimportant. But yes, you know, we look at interpreting the Charter of Rights. How has the courts over time within the jurisprudence interpreted and applied? I mean, that's 11 and 13. Interpreted and applied the, now not the, of course, like I said, with the charter, you can be impugning either legislation or action, but usually most likely will be an action than a legislation, right? So you're not necessarily interpreting an action. The court in the terms of charter rights, when we talk about interpretation, we're interpreting the charter itself, the constitution itself, the sections of the constitution that provide for the charter rights. Whereas in the context of division of powers, we're interpreting the impugned legislation, right? So those principles that I highlighted earlier on peace of substance, colorability, are all applied not to the constitution, right, but to the impugned legislation. And chapter 6, 7, 8, 9 are interpreting the constitution, right, 91 and 92, and a few of the subject heads provided in 91 and 92. But when it comes to the charter, the court is interpreting the charter itself, you know, sections 2, section 7, sections 15. What should this mean? How expansive, you know, if section 7 says you have a right to life, liberty, and security, what exactly should life include? How should we interpret liberty, right? Should it only include whether you have been imprisoned or not? And you're not free to go out, so to do what you know, or should it include your ability to practice your profession, right? Should it include your ability to decide as a woman that I don't want to have, or I want to have an abortion, right? Those are the things you know that we're looking at when we talk about interpretation and application of the charter, right? When we talk about expression, everyone is guaranteed the rights to expressive activities, you know, blah blah blah. Section 2 A or B, I don't know, or you know, what exactly does expression entail? What does it constitute? To what extent will afford you the protection of expression? What activities, if you say, oh, somebody didn't let me do this, what I wanted to do. If we look at that, if we interpret expression, would we interpret it to include that thing you wanted to do that the government didn't let you do? That's the conversation to have when you talk about interpretation of the charter rights. And what you need to know, just, you know, as a cheat sheet, is that the courts have adopted a very expansive approach. So the interpretation, I mean, the approach that the court has adopted in interpreting charter rights is not restrictive. It's very liberal. It's very expansive, just to ensure, I mean, in the spirit of the charter itself, the spirit of the charter is to protect individuals, protect their rights, help them to live a better quality of life. And so the courts have also adopted an expansive approach. It's not likely that when you come and say, oh, I wanted to do this and I wasn't allowed to do it, it's not likely that the court will hold that, oh, you didn't even have a right to do it in the first place, because the approach is expansive, the approach is progressive, the approach is purposive, like in line and in alignment with the purpose of the charter itself. Application, look at that in terms of the benefit and the burden. Who enjoys the benefit of the charter? Who bears the burden of the charter? Without wasting too much time, of course, individuals, citizens, we bear, or rather we enjoy the benefits of the charter, and governments bear the burden of the charter. There's a whole conversation to have when you talk about burden under application. Who is government? What is government? Right? Because of course the charter will only apply to governmental bodies. It will not regulate private relations, right? Who is government? What is government? What happens when private relations are broken down and infringed what should be a charter right, even though we have established that the charter doesn't apply to individuals? Those are conversations that you should, you know, or things you should be mindful of when you start to study chapters. Excuse me 1 minute, please. I apologize. Right? So those are conversations that, or rather, those are things you want to be mindful of when you're reading your 11, your 12 and 13, right? Straightforward, nothing spooky, trust me. Straightforward. Overrides of rights is your cheapest topic. And it's a good exam question spot. It just means that despite the fact that sections 1 provides and guarantees charter rights, they can be overridden by the government. That's what section 33 says. Remember, I highlighted 33 for you when you're studying Aboriginal rights. Pay attention to the interaction between section 35 and 33. Can a government override a section 35 rights? Can a legislative body override all the charter rights, right? What does the legislative body need to do to trigger the override section? To validly trigger the override section. Limitation of rights, real quick in 2 lines. Section 91 guarantees the rights, but it also provides that they can be limited as is demonstrably justifiable within a civil society, civil and democratic society. Now there's a confusion that candidates have, and they just jump into the Oakes test and say that R and Oakes is what provides for limitation of the right. What provides for limitation of the right is section 1. Section 1, Constitution Act 1982 provides for limitation of the right. I mean, we're out of time. I would have invited somebody to read section 1. Right? It guarantees the rights. These rights are hereby provided and guaranteed, blah, 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 and they can only be limited as is demonstrably justified within a free and a democratic society. So it provides that whilst these rights are guaranteed, we also are aware and admit that certain times or for certain purposes, they can be limited, they can be infringed, they can be breached. It's okay. But for you to do that, you must be able to demonstrably justify that limitation against the backdrop of a free and democratic, the values of a free and democratic society. Now, it is in interpreting. Remember, I said that whilst with interpreting the charter, the court is interpreting the charter itself, the sections, the law, the constitution itself. It was in interpreting section 1 in R and Oakes case that the court laid down the test, the Oakes test, that the court will adopt in applying section 1 to justify a limitation. Right? That's the conversation to have with chapter 15. Now I'm flying through it because we're already out. I mean, my partners are going to fire me, especially if none of you eventually comes to register. Oh, by the way, I need to say that we have an early bird discount that's ending today, a 10% discount. So if you decide or make a decision that you would be interested in the classes or you need tutoring help and you'll be interested in the classes, it's better that you do it today because discounts might not be there anymore. So chapter 16 to 19. And I apologize, I'm running through it real fast now. But 16 to 19 are really just the handful of charter rights that the NCA has, mandated us to understudy. They're not all the charter rights, they're just the ones that are important for the purpose of passing the exams. Right? And the freedom of conscience and religion, which is chapter 16, right? Provided for by 2A. Freedom of expression, chapter 17, provided for by section 2B. Freedom rights to life, liberty, and security of the person, provided for by section 7 of the charter. And excuse me, and right to equality, provided for by section 15 of the charter, and that's your chapter 19 in the syllabus. So from 16 to 19 are just individual charter rights that the syllabus has highlighted for us to deeply understudy. Now, my cheat sheets to you to help your study is realize that, or rather read knowing that, bearing in mind that these rights, I think we highlighted 4, all have tests, right? Certain things that you as the applicant who's alleging an infringement of your charter right must establish before the court is convinced that, okay, yes, a charter right has been triggered, right? So structure your reading or your studying in that way. Identify the test, what you need to establish if you're claiming an infringement of your freedom of expression of conscience and religion, if you're claiming an infringement of your freedom of expression, equality, life and liberty and security. What do you need to establish? At what point is the onus of establishing this burden of proof on you as the applicant, right? And then when it comes to limitation or justifying that, yes, we agree. I mean, the Crown now comes on the other hand to say, I mean, the court says, yes, we see that you've established that your right was infringed or limited. So, oh, you Crown, oh, you government, why did you limit her rights, right? At that point, you have discharged your burden and the burden moves to the Crown. What will the Crown establish? Is pretty much the Oakes test, right? Establish that it was limited for a substantial legislative objective, establish that it was minimally impairing, it was proportionate, there was a rational connection between, the purpose of the law and the means that eventually impacted on your right. At that point, the Oakes test, bear at the back of your mind that the Oakes test, the section 1, justification of the limitation is not your business as the applicant, because you're not the one who has limited somebody's rights. It's the burden of proof is always on the government. The burden that you bear as an applicant whose right has been infringed is the burden of establishing that you have the right and the right has been infringed. And that's what I say when you're studying, bear in mind that there's a test. So when you're studying, by the time you're able to say you are done studying, you should have each charter right highlighted in syllabus, have, test for life, liberty, and security, test for equality, test for expression, test for religion, right? And then you deeply understand the Oakes test, because every time you have a question that touches on a charter infringement that, calls for a constitutional challenge or a judicial review on charter grounds, you have to do both. You have to start your judicial review first on the side of the party whose right has been infringed, by establishing the test, establishing that, yes, she had that right, her action or her conduct or activity could have been afforded or should have been afforded the protection of that right or of that section, establish that that right was breached or infringed, right? Then move in answering that one question, that's the first part, then you move to play the devil's advocate for the Crown as well, to say, yes, we infringed her right. Yes, we arrested her or detained her and infringed or breached her right to liberty. But here's why we did it. And then answer those 4 questions that were laid down in Aaron Oakes. Substantial legislative objective, rational connection, proportionality, minimal impairment, right? And then lastly, remedies. Remedies, when you're studying remedies, pay attention to section 52 and section 24. Which of the remedies are provided for by section 52? The remedies provided for by section 52, what are their features? What are their characteristics? What is their scope, right? And what is their applicability? The remedies provided for by sections 24, what's the scope? What's the applicability? Who do they apply to? How can the court apply them? Because even though remedies are ordered or ordered by the court at the court's discretion, that discretion must be exercised judiciously and cautiously by the courts, right? So what principles guide the court in its exercise of the discretion of awarding remedies? Pay attention to the Shakhtar case. Divya, did you come across the Shakhtar case in studying remedies? Very important. I got a question. Remember my 10 6-mark questions? One of those 10 questions was the Shakhtar Principle. So you see why I say that if you haven't at least read through it once before, and you get a question like that, you approach the exam thinking, oh, once I know division of power and I know charter, I'm good. You don't know it, you are lost. And you've lost that mark or those marks. So when you're reading remedies, 3 things: pay attention to those 2 sections, 52 and 24, and pay attention to the Shakhtar criteria, the Shakhtar Principle or the Shakhtar criteria as laid down in the Shakhtar case. I don't remember the title of the case, something as Shakhtar, maybe R and Shakhtar, but Shakhtar, the Shakhtar Principle or the Shakhtar criteria rather. And so, I mean, I mean, we ran through the syllabus. I've taken a bit of your time, just as you have taken a bit of my time as well. And you guys have put me at the risk of being fired by my partners for exceeding 2 hours. But let me say, you know, once again, that we offer paid tutoring services. Our structure, my approach personally is not to, I mean, I know candidates want the easy way out, but my approach is easy, but it's also, in my opinion, more foolproof. I don't do just division of power and charter. I make sure that I take you as concisely and as impactful through almost every nook and cranny of the course content, so that regardless of how the NCA presents the questions, you at least have an idea where to go to. And I also aim at ensuring that my candidates are able to substantially write off the top of their heads from their residual memory for, you know, a while before you go into flipping the pages, because you realize that with open book exams, it's a ditch, it's a trick. Sometimes it can be more of a curse than a blessing, because you're tempted to think, oh, I'll check it when I get to the exam, and you're flipping through. I mean, you know how thick Hugs is? I don't have mine on my table right now, right? And even if you don't do Hugs, you do the material circulating. Some of them has almost 200 pages, right? And then sometimes, even with the NCA questions, I mean, with the NCAs, is the more you look, the less you see. You're staring at the materials, you're reading it, but you don't know how to apply it to the questions, right? So my approach is run my candidates through as much as I can, almost all the nooks and crannies of the course content of the syllabus. Avert your mind, you know, I position myself as an NC examiner. Like, with this chapter, what possible questions can I ask you to just disorient you, right? To make you confused, right? I suggest those to you. We review them together such that, you know, you're not displaced or thrown off when you get into the exam hall and you see the questions, right? And today we have, or I think, yeah, just for today, we have a 10% early bird discount. And if you come for the classes, of course, you get this. I forward them to you. I think the most I have is 4 pages on chapter 4, because chapter 4 is quite a lot. There are quite a few big doctrines and principles that we need to run through. So I forward it to you per class, per session, so that before you come for the session, you read through. The most you ever get per session will probably 6 to 10 pages. So you read through, and then we base our conversation off of, you know, that. And hopefully, you know, what other expansive study you've done. I'm not a tutor that I will say to you, all you need to read is my 2 pages. No, that's not all you need to read. If you read them and you come to class and we have a conversation, you have a good enough ground. But I'll always advise that you read as much as you can. Read the recommended materials, read, you know, the text contained in the syllabus if you can. But if you choose, personally decide that you don't want to read and you want to stick with this, plus my conversations and my explanations, you know, and our back and forth rubbing of minds during the 4-hour sessions, then you should also be good to a large extent, right? So there you have it. Thank you so much for your time. Hopefully, I've helped you guys more than confused you guys, right? And yeah, hopefully I see you in my paid classes, right? Thank you very much.
Thank you so much.
You're welcome.